Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I want to talk about the Order in Council, which banned a whole bunch of firearms recently, but in particular I want to talk about the amnesty and the hunting provisions, which have been somewhat controversial, often misunderstood, and why I think they're essentially a false promise, why I think they're kind of deceptive. But before I get to that, I want to cover a little bit of housekeeping. So the first thing is I'm not wearing a poppy right now, notwithstanding that this video is probably going to go live tomorrow on Remembrance Day. And the reason for that is I just couldn't find one. This is the first year I haven't been able to find a physical poppy. I made a donation online, but I'm kind of upset that I couldn't find one. So that's the only reason I'm not. The next thing here is I don't normally get very political on this channel. I try to avoid it sort of to the extent I can. But I'm feeling a little bit salty, so I'm going to break my rule. And that's because tomorrow I'm sure we're going to see Trudeau talking about how, he respects veterans and he honors their sacrifices. And yet when it came time to deliver on that, his comment was, well, they're asking for more than we can give right now. And I get it. Politics is full of tough considerations, tough choices. But man, was that a flippant, insulting response. And it's even more insulting when we start thinking about this Order in Council that I'm talking about today. Because one of the things they banned is the AR-15. And one of the groups that the AR-15 is most popular with is veterans. When I went to service rifle matches, and I don't get out to as many of them as I'd like, but most of the people there are veterans. I'm an odd person out not being so. And the AR-15 was quite popular in that setting. So the people who are targeted by this Order in Council includes a lot of Canadian veterans. And he's saying we don't have enough money to support them in terms of, medical care and so forth. But they sure have money to push through this ban, because this ban's going to cost them a ton of money. If they're doing a buyback, that's going to be huge dollars. But even if they're not, they're going to have a whole lot of money that they spend on enforcement and compliance, including kicking down the doors of some of these same veterans. So I'm just kind of feeling this sort of knot in my stomach, I guess, this rising bile at the thought that tomorrow we're going to see, these comments, and it just doesn't fit with what's actually happening here. I don't normally like to go on political rants, but I'm breaking my rule for this one because a lot of my clients have been, military veterans. I've been quite honored to be able to assist some of these individuals, but a lot of these same people are going to be the people losing their property and potentially facing criminal sanction. So enough of that rant, I guess. Let's go on and talk about what I meant to talk about here, which is the Order in Council itself. And in particular, I want to look at this provision. This is from the amnesty order. So once this Order in Council went through, it is prima facie illegal to own any of the affected items. They're just banned. You can't have them. However, there are certain exceptions in the amnesty order. This provides a defense where you'd have to present some evidence to at least raise the issue, and then the Crown would have to prove that it's not the case beyond a reasonable doubt. But let's have a look at this section, and this is section I. This says, if the specified firearm was, on the day before the day on which this order comes into force, a non-restricted firearm, use it to hunt in the exercise of a right recognized and affirmed by Section 35 of the Constitution Act 1982, or to sustain the person or their family until they are able to obtain another firearm for that use, and for that purpose transport the firearm in accordance with the regulations. So there's a couple of things that have been commonly reported that are misinterpretations here. One of them is people say that the Section 35 portion, which is the Aboriginal hunting rights, they say, oh, well, Aboriginal people get to hunt with AR-15s now. And that's not actually the case, because the AR-15s were restricted beforehand, and this only applies to a non-restricted firearm. So if somebody takes an AR-15 out hunting under this provision, they're at risk of prosecution and jail. But the bigger thing here it may be fairly easy to establish that you've got Section 35 hunting rights. If you're an Aboriginal person and you enjoy those hunting rights, that's probably been well recognized before today. Sustenance hunting is typically harder to establish. So people who are saying that they're sustenance hunters may have a more difficult time. But that's not the part that, in my view, is really fatal here. The part that is basically undermines all of this and makes this, in my view, essentially a trap or a lie. This is something where if you're saying, I'm going to use this section so that I can go out and hunt with, for instance, a Mini 30, which was a very popular rifle on reserves, and that I'm going to be fine, I don't think so. I think you'd be crazy to rely on this section. I think you'd be crazy to hunt with any of the firearms that they've specified as prohibited because of this portion right here, which says, until they are not able to obtain another firearm for that use. So, in order to establish this, you have to establish some air of reality to the notion that you weren't able to obtain another firearm for that use. So if you're taking your Mini 30 out deer hunting, you'd have to establish that you couldn't have obtained another firearm for that use. That's a problem because the SKS is legal to hunt deer with. So they're going to say, well, why couldn't you get an SKS, which is a $300 rifle these days? You're saying you couldn't possibly get one? You couldn't borrow one? You know, they might find somebody in your friends and family who is willing to say, well, yeah, I guess I would have loaned them this rifle. If you own more than one gun and you just simply prefer to use that one hunting because it's the one you always use hunting, they'll go through your stack of whatever firearms you own and say, well, you're not under this section because you own this other gun that would have been legal to use for deer hunting or for hunting whatever animal. Now you might be thinking, well, sure, maybe I have this SKS and I could, I guess, take it deer hunting. I mean, an SKS is not exactly a high precision rifle. They're an inexpensive rifle. They're a budget rifle. But you might think, well, this other one that I have that is covered by this prohibition is such a better gun. You know I can get clean, ethical kills with it because it fires the appropriate cartridge and because it's very accurate, allowing me to achieve the shot placement I want. Well, I wouldn't rely on that because the law here says until you're able to obtain another firearm for that use. It doesn't say obtain another firearm for that use of equal quality or that you like as much. It just says some other firearm for that use. So, and think about this in terms of if you're there, you're up on the stand, you're saying, I wasn't able to get another gun for that use. Crown might be there saying, well, don't you have a Cabela's in your area? Look at these guns that they're selling. Look at how inexpensive they are. They might say, here's a gun I found online for sale. Couldn't you have bought this one? Your brother owns this other gun. You couldn't have borrowed it from him? And so on and so on. This section is so badly written that it really falls into that area where it's hard to tell if this was incompetence or malice. And I guess I'm willing to give them incompetence on this one because I've seen that they are not drafted these well in several places. This is not the only place where they seem to have screwed up. But it's really a screw up that lays a trap for somebody who's relying on this in good faith. And, if you might be saying, oh, well, I'm thankful that they provided an exception for me. Don't be, because I would not use that exception if I was, in those shoes. And sometimes I've seen people expressing envy. They've said, this other group is allowed to take their guns out hunting. Why can't I? Don't be envious because this is not a helpful provision. This is a trap provision. This is something that is potentially able to get you into a fair bit of trouble. And it's so dangerous if you were to rely on it. It's just incredibly dangerous, the risk of prosecution here. And not prosecution on something light. We're talking about, possession of prohibited firearm without a license, possession of prohibited firearm with ammunition and no license, possession in a motor vehicle, possession at unauthorized place. These charges stack up and stack up and stack up, and they have some serious penalties, which can include fines, probation, jail. You know, jail is very much on the table with this sort of charge. And the big, or one that's, you know, kind of perverse here is firearms prohibition. Because, you know, when they're saying, oh, we want to make sure that people can hunt, you know, using this, well, if they did, they run the risk of being banned from using those same guns and all other guns. Anyway, that's my rant on this one. I know I may be sort of breaking my rule today on politics in more than one way, but this one really annoys me. If you found this to be useful, please like the content. Please share it with your friends. Please subscribe to see more content. And I also want to thank $30 Patreon supporter Steve Browning, $50 Patreon supporters George and D. Mo, as well as a long list of $10 Patreon supporters. I'm going to try to get through them all. I kind of feel like I've been shortchanging you guys with the scroll, but sometimes it's easier than saying them all. But Ma Buddy Keith, Process Eng, Stephen Larson, Mark D., General Counsel of the CCFR, John Robinson, Tim Rogers, Roy Haddock, Frecklestack, Jean-Alexandre Tessier, Cameron Johnson, Sir Goat, Sights and Arms Limited, Chaba Hollow, Peter H., Craig Kwan, Akin Coxall, North Central Process Service, Toys Are for Boys, Ian Vaughn, Milan Vrakic, Terrence Griffiths, Doug Thompson, Brad Crooker, Jason Harrington, Lee Kiso, Mark Stout, Scott Sweetman, Mike Rhodes, Alvaro Batarier, DF, Stacey Cartmel, Tactical Advantage TV Canada, Ian S., Dave Leslie, Juan, Donald Duncan, Stephen Conquest, Darren Duell, Matt H., Kevin, and Sean Crane. Thank you. It is much appreciated. I'm looking to do some more videos that involve some testing, including one that actually has the potential to change the law for the better for especially airsofters, or the group I'm looking at here. But I'm hoping I can actually sort of push the law through a clever experiment. Anyway, so I want to thank all of my supporters. It's really appreciated. And until next time, I hope this is Armed with Knowledge.